What is MIAM? A conversation with Katy Harris of Mediation Matters Midlands. That is our conversation for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hi everyone, welcome back to Lawyers, Mediators International. I'm Mac Pierre-Louis, where we talk about law and mediation topics to educate the public, both professionals and everyday people. Welcome back to the show. And so today we have special guest Katy Harris of the UK, who's joining us across the pond, who's going to be talking to us today about her work, her journey, and something that's going to, I guess, connect really well with mediators, lawyers, judges, anybody who's interested in helping families succeed after divorce and separation. And so that's the thing that we're going to be hitting really hard on today with somebody who is experienced, who has a law degree, but who's a full-time mediator herself, who's done a lot of work in this area, who's a speaker, who's gone around the world to speak on this topic, and who I got a chance to meet briefly out in Chicago sometime earlier this year. And so welcome to the show, Katy. How are you doing?
I'm good, thank you. How are you?
Good. Thank you so much. And I probably already messed up your name by calling you Katy instead of
That's
KT.
fine. It's fine. Interchangeable.
Well, no, I appreciate that. And so, like I said, these conversations are typically pretty chilled and laid back. We want to just educate people in a way that doesn't feel like we're lecturing to them, but we're bringing education and knowledge. And so before we get into MIAM, this mediation information and assessment meeting, this thing that's happening out there that I think is very insightful and progressive and should be implemented in many of our courts here in the U.S. Before we get into that topic, let's learn more about you and welcome back to the show. So tell me a little bit about yourself and then make sure you tell us where you've been in the U.S. because you've traveled quite a bit in America.
Yeah. So as you said, I'm a mediator. I've got 2 companies in the UK. I have a huge passion for trying to make the system less adversarial and focusing more on alternative dispute resolution. That's a big focus of mine with early intervention and alternative resolution, as I said. So keeping children at the heart of any separating families and really supporting the parents who are going through separation. So yes, we traveled a couple of times. So I was in Austin, Texas last year, and San Antonio. Got the pleasure of visiting there when we were working in a school teaching on conflict resolution and mediation skills. And then I was at the Chicago ABA conference where I think we met originally. I'm heading off to Charleston in South Carolina in, I think, just under 2 weeks. So I'm going to speak at a conference there. And then we've got our big conference in London in March 2026.
Yes, so that's exciting. The big conference in March 2026, which was recently announced, is going to be the Bridging the Gap, Aldgate, London, UK. And I believe that's March 19th specifically. I'm hoping I can participate and be there. If not, then I'll definitely have you back on to talk about it.
It's 2 days, the 19th and the 20th of March. So, it's going to be good. I'm looking forward to it.
Yes. And so it's all about bringing together people who know this area of conflict resolution really well over children so that we can help parents navigate the whole separation and divorce thing in a way that's going to be child focused.
Yeah.
And it's
Sorry, you go.
And so there are going to be some pretty big names like Bill Eddy, is set to speak there. And you announced it on LinkedIn, but of course, it's on Facebook as well. And so folks who want to learn more can certainly go to your LinkedIn page on LinkedIn and check it out. Yeah, go ahead.
Yep, and the website will be up in hopefully within the next 2 weeks, and tickets will be available as well at that point. We'll be
Yeah.
releasing more information, possibly not day by day, but every couple of days we'll be releasing more information on what's going on with that. It's all very exciting. So I was going to say something else, and I'm not sure what it was now, but
Yeah.
it was
It'll
oh,
come back to you. You go ahead.
it was about bridging. So it is bridging the gap. So we're looking at where I think in every all around the world in family law, there seems to be so many people working in these silos, a lot of people pushing for change, but in their own ways, and there's these big gaps between lawyers, solicitors, obviously similar to you guys, and mediators, arbitrators, the schools. There's just so many gaps, and I'm trying to push for a more united approach so that we've got a real network of support for anyone who's going through separation, in particular where there's children involved.
Yes, yes. And that's the big focus of your own business, right? Mediation Matters Midland, where
Yeah.
you bring together a lot of different people from different disciplines
Yeah.
to help parties navigate the post separation and divorce process. Can you talk briefly about that? Why is your setup different than you would say a traditional mediation office where it's just a mediator? How are you different?
Well, there's not many things I can say I'm very good at, but mediating is one of the things that I do excel at. And I do believe that most people are very good at one particular thing, and I'm not a solicitor, I'm not a therapist. However, I link in with many people who share with me their expertise, but they're always better placed to help people. I would rather be an expert in my area and work with other people who are experts in theirs, rather than be a jack of all trades and not doing anything particularly well. So as a divorcee, someone who's been through the system, through the court system, both children and finance, I found that we were wholly let down by many of the systems, and I just think there needs to be much more support for particularly parents struggling, trying to co-parent or trying to maintain some sort of relationship with the other parent. It's virtually impossible, and the system pulls us apart and pushes us in many ways into a battle. And we need to work away from that without moving away from the blame and moving much more towards a focus on resolution.
Yes, yes. So when you say the system pushes us apart, this now gets us into the topic of the day. I believe you agree with me, right? What we've seen in the court systems is that when people participate in adversarial settings, it ironically promotes more division and it
Yeah.
promotes more divisiveness and it creates more conflict between parties. And the person who always gets stuck in the middle, of course, is the child.
Mm-hmm.
And it impacts kids negatively. And I've always said that many parents don't really know how this is supposed to work, how this co-parenting thing is supposed to work, because let's face it, they're never given the skills. But that's where you come in. And then that's where the project that you are helping co-pilot in one of the core systems out there comes in, and that is called MIAM, Mediation Information and Assessment Meeting. Can you tell us a little bit about that? What was your role in its development, if there was any, and then we can segue into the details of how it works.
Okay. So MIAMs have now been around for quite some time. I had no involvement in the development of them. I would have loved to have done, but I didn't. So essentially, before we ever mediate with families in the UK, anyone who is trained, most of us are trained, and we follow the code of conduct from the Family Mediation Council, which is what you're looking at now. And it basically states that before we engage any people in mediation, even consider bringing them into the same space, we undertake what's known as a MIAM. And that is a mediation information assessment meeting. It's facilitated by a mediator. And the purpose of that is to meet confidentially with each of the clients. You guys in a more legal world would refer to them as parties. We refer to them as clients because we like to keep away from the legal jargon, make it a bit more humane. So we speak to both of the parties individually. We understand a little bit from their point of view, their narrative of what's happened. It's usually the same story, but different perspective on what's happened. We do our safeguarding checks. We talk to them about what their options are. with regards to their next steps, whether it is an application to court, whether it is to utilise solicitors, whether it is to move towards mediation, where we still say absolutely that they still need to get legal advice. As I said, this isn't I'm not a one trip pony where I'm kind of like taking on everything. It needs to be shared and distributed between people who give the correct information, and people who are skilled in that area, so that we avoid that battle. So the MIAM, it's a huge part of what we do. Any mediator in the UK will know exactly what a MIAM is, any trained mediator. So it's so important now that you can't make an application to the courts in the UK without having attended a MIAM. And in fact, you also then need to provide what's known as the MIAM certificate or mediation certificate. And that is essentially one of the pages of the C100 application, which is the application for children, or the Form A. There's a page in there. It has to state when you've attended a MIAM and the date of that, and the application to court has to be made within 4 months of that date as well. If it goes beyond that 4 months, you have to go back, have another MIAM, because the courts are wanting for people to only go to court with an informed mind, so that they know what their options are, they know what the potential costs are, the risks are, the maybe the positives, both pros and cons for any of the services. But our view is always start at the lowest level that you can and then escalate it if needs be. The problem we have is the courts have the power, of course, to make orders and make decisions, but they don't have the time and the capacity. It's not their role to support people emotionally, therapeutically, and ultimately any court order in any land is going to struggle to have any sort of longevity if the parents aren't able to communicate. So a big part of what we believe is important for a MIAM is understanding what the communication is like between the parties, how can it be improved, and even if they don't proceed into the mediation arena, that MIAM gives them signposting information, parenting apps, different techniques that they might use, and all of the information so that they make an informed choice as to where they go next.
Yes. And is there a cost for this, and roughly how much?
So in the UK, again, we've got what's known as the family mediation voucher. So a MIAM is required whether you're discussing finance, children, or both, whether it's an AIM case. So we call them AIM, all issues mediations. And where there's a case involving children, our government actually provides, the Ministry of Justice provides £500 worth of mediation costs for anyone who's discussing any child arrangements. That doesn't cover the cost of the MIAM. So the MIAM ours are about £125 per person, including VAT. Others, I would say they probably sit somewhere between maybe 100 and 160, 70, depending on where you are in the country. But I would say our cost is probably around average.
Okay, so let me try and understand. The MIAM is really to get to the dynamics at play between the parties and to see whether or not mediation is suitable, and basically get the parties ready for actual mediation or maybe attending court, right?
Yeah, and safeguarding is a big part of it as well. So, of course, we follow our safeguarding checks. We check with regards to domestic abuse, but also mental health, any substance abuse. And a lot of it is about where can we, so in answer to the question, why are we different and how do we work differently? We take a very therapeutic approach to mediation, and I see my role as being there in that MIAM to provide as much information, as much signposting to other services as possible, so that people can go and seek that support from wherever they need it.
Yeah, no, it's very important when we talk about these differences, because the way you're doing it, I think there are lots of benefits. Okay, mm-hmm. It gets people to think mediation first versus litigation first. Here, especially in the jurisdictions that I work in, you sue first, and then you are ordered to go to mediation. The good news is you are ordered to mediate. However, one of the downsides is the court doesn't even ask whether or not it's suitable, because what if there is domestic violence? Now, the law does allow for you to request an exemption and not mediate because of violence, but that's on you. And many times you have pro se litigants who don't have lawyers, who don't know that they have the option to opt out, and with the court's permission, of course. And so we do things a little bit backwards. And I think when MIAMs came about in your jurisdiction, was that because of a reaction to how things were being done? Or like what was the genesis of it?
I think probably the original thought behind it was probably more so the safeguarding that
Yeah.
probably brought it in initially was, are we in a position to bring two people into what originally was same space?
Yeah.
Pre-COVID, mediation was
Correct.
always held in person.
Correct.
So, is it appropriate to bring two people potentially in conflict into the same space without doing those checks? So, I would imagine, I don't actually know the answer, but I would imagine that the reason for that initially would have been to do with the fact that there needs to be safeguarding checks, making sure that those people, one, that there's some sort of equality and that they're able to mediate, that they've got capacity to be able to mediate, that they're emotionally ready to mediate. But the bigger part of it would have been, how can we keep these clients safe
Yeah.
and keep them in this mediation room without there being a risk to either one of them? And on the domestic abuse side, there's been many changes, in particular over the last probably 2-3 years in the UK. There did used to be, and there still is, a lot of thought around if there's domestic abuse, mediation isn't appropriate. But I have a very different view, which is that not any, but many victims of domestic abuse actually would be empowered by mediation and taking back that control and ability to make decisions for them and their children, as opposed to allowing for a judge or a magistrate to take that entire decision away from them and make a choice for their children, a person who they've never met and know nothing about. So having that ability is really important. We've now got a secondary kind of net to catch things. So the MIAMs were also introduced to prevent immediately going to court and not knowing about what options are available, and putting it in court hands where we know exactly as you said, it's an arbitrary system, isn't it? And it creates conflict, and it doesn't promote co-parenting. It doesn't do any of those things to support it. So our courts now are pushing back even harder. So even if they have the MIAM certificate, because we have to sign that, it gives very little information. It basically says, have they both attended a MIAM or just one? And then the next category, it's a very overview. It's kind of like, have they attended and mediation's broken down, or has one of the parties decided not to engage, or you deem it not appropriate? And those two fit within the same line. So for me, particularly where there might be domestic abuse or worries, that person doesn't want to engage in mediation because they're worried, and they don't have the voluntary requirement, because we have the requirement for it to be voluntary. So if someone isn't choosing to mediate, as far as I'm concerned as a mediator, it doesn't reach the requirements for mediation anyway, because we're not fulfilling the requirement for it to be a wholly voluntary process for the person who's engaging. And that's really important for us. So we would tick that box that says it's not suitable for mediation based on the fact that there isn't the voluntary element from both parties at that point.
So does that mean that MIAMs are just one-to-one when they start just between the assessor and the party? It's not a joint session with everybody?
No, it's a separate session, and it's wholly confidential as well, even from the other party. So it means that that person has got a safe space to disclose anything that they've got concerns about. It's kept confidential from everybody, including the other party, unless there is a disclosure of safeguarding concerns, in which case we'd have to report to the relevant authority, and or any involvement in criminal activity or money laundering, etc.
Gotcha. So it seems to me the whole MIAM process has now been built in to your, I guess, court system at the very front end. Is an expected thing that people have to participate in before real court begins.
Yeah.
And in our jurisdiction, I guess we have something a little similar, but it's completely not similar. And what I mean by that is we're expected to go to mediation. Okay, so you file the lawsuit, you go to mediation, and most of the mediators down here will start the parties off in individual caucuses. You find out what the issues are, and you decide whether or not it's good to bring them together. Sadly, most of the time we don't bring them together, which I think is not transformative enough, It doesn't help the process, but that's just how it is. And even when you do try to bring people together, sometimes the lawyers on both sides insist, oh, no, I don't want the parties,
Yeah.
getting together. So as a practice, it's just evolved that way down here in Southeast Texas. But a lot of times we do begin with the parties separate so that we can kind of get to the issues. And that part is confidential. But we're doing it in the same mediation session.
Yeah.
Whereas you guys are doing it, the MIAM is first, it's its own meeting, probably lasting maybe an hour, one-on-one. And then you decide if you're going to then have a future mediation. Is that what I understand correctly?
Yeah. So after that initial meeting, both parties have the chance to decide, do we wish to proceed with mediation or not? And the mediator also makes a decision. So even if both parties say yes, but for the mediator it's not going to work for whatever reason, we have the ability to say no. So if any one party says no, it doesn't happen, provided everyone is in agreement, then the mediation, then we arrange for that meeting. And we don't have so I did my civil training after I did my family mediation training, and that was the first time I ever came across caucus work. We wouldn't, so we call it shuttle or separate space mediation. In family when we move into separate spaces, but we don't have the same as you would have in civil mediation, where you would have separate spaces and like that extra layer of confidentiality. We don't have that in family mediation. Everything is transparent. There are no secrets. So once the MIAM is completed, that's the only time that there's any confidential information shared. Otherwise, we don't reply to emails without copying each person in. Nothing. It has to remain transparent, because we believe that if there's any conversation separately, one party may say you weren't acting impartially, and obviously our job as a mediator is to retain that impartiality and make sure we're offering each of them an equal level of support.
A good point. That is always a risk we run whenever we keep the parties separate, and then the parties talk later, and then they start saying, "Oh, the mediator said this, mediator said that."
Yep. And it's just another reason why there's conflict, isn't it? And I can say to you now, I'm not sure, how are you going to manage with not being able to see your children 2 times a week or something? And then that person's going to relate to the other one, oh, the mediator was really shocked that you could only see the child. And it's like, no, the mediator wasn't. And if you weren't in that moment when I said it, how do you know how I said it? So again, it's creating more and more of those opportunities for there to be more and more conflict and uncertainty. And in, I would say, 95% of the cases I deal with, the issue is communication and trust.
Exactly.
So being able to rebuild that, as much as it might be difficult to be in that same room, the longer 2 people are apart and that communication breaks down, the more and more and more their perception of that other person is that they are a monster and that they're terrible and they're never going to be good. And then you bring them into the same space and they actually have that conversation. It's like, actually, you're not as bad as I thought you were. Still, they don't really like each other, but there isn't this real monster that they've convinced themselves that the other person is, often because there's been a solicitor behind the letters and enhancing that conflict and kind of trying to be assertive. And we still have many solicitors who write letters who are perceived to be very bully boy tactics, and that's not nice for anyone to receive, particularly when you're talking about somebody's children.
Yeah, well, we call that being a pit bull here. Okay, the aggressiveness, the pit bull nature of some attorneys to just want to quote unquote win, whereas in family law, let's face it, there's not a lot of winners. Usually, everyone's is kind of losing because there's a divorce, there's a separation, and there's a child who's in the middle. Yeah. And so, do you guys have lawyers in the mediation with you, or do you kick them out?
We can have, but we very rarely do. I think this is probably an important point also of how I've come to where I am. So as I think you mentioned, I've got a law degree. My intention was I actually intended to go into criminal law. And then I realized very quickly that actually I'm a terrible person at needing justice to be correct. And could I really stand and defend somebody or accuse someone of doing something that I genuinely didn't believe was correct? So I'd be a terrible lawyer or a barrister because I'm too ethical. And I think that's great for it. It's a brilliant trait to have as a mediator. It's a terrible trait to have if you're a solicitor, because nobody goes and says, I'm going to go and I'm going to instruct the solicitor because they're really fair and equal. They say, I'm going to go and instruct the solicitor because they've won X, Y, and Z amount of cases and they're an absolute pit bull and I want to win. So, you know, I think it's important. There's the two very different roles. That there's a requirement for both, but there's the lawyers out there that, you know, they've got that brilliant reputation and they do really well at their job, but are they doing the right thing?
Yeah.
No, not necessarily. And I think that's probably why I am quite opposed to the courts and that system, because ultimately it's driven also by money and reputation, as opposed to being parent focused and child focused, which is exactly what we need to do.
Yes, and which is why you are part of the Amicable Divorce Network. You know, correct?
Yeah.
Now that's a U.S.-based organization. However, and I'll share my screen, and I'd like for you to talk a little bit about that, because I learned, I think I knew about it quite some time on social media and LinkedIn, but I learned more about it in Chicago when you guys were there.
And I think for me, this is probably a bigger thing in the US than it is in the UK, because we have, I think, already a slightly softer system. But I think for you guys over there, so this was set up by Tracy Ann Morgrant, and you can just see her there on the podcast picture.
Yes.
She's a divorce attorney. She's a partner as well, and she set this up because she'd had enough of exactly what we just talked about, that fight in court, that battle, that let's win. So she set this up so that there is a requirement for, I think it's classed as fair fee something. I can't remember how she says it, but basically it's to make sure that people aren't using cases just to earn money. So I think it's fair fee practice or something along those lines. So essentially she set out principles that are required for anyone who wishes to take part in the Amicable Divorce Network, and that is to ensure that there is a network of professionals who are there, all of whom have the same idea and need to keep things as amicable as possible, knowing that actually moving people towards solutions and resolution based, as opposed to a battle where the best solicitor will win or something similar, is not a good, you know, great, that's great for that person, but that's not great for that family moving forward, and it's certainly not great for the child or children that are involved. So yeah, the Amicable Divorce Network, if you you look into that, that's what it's for. It's basically, I suppose it's similar to what we have over here as well, another thing called resolution, which tends to be solicitors who often then train as mediators because they want that amicable outcome. Tracy has brought over the Amicable Divorce Network to the UK, which is how I was introduced to her in the first place. And in fact, it is Tracy from the Amicable Divorce Network who is co-hosting the Bridging the Gap conference with me in March 2026.
Exactly. And is Tracy also the one who will be doing the Charleston event coming up this month?
Yep, she has I think this is their big annual conference in Charleston, on the, I don't even know, 5th and 6th, I think it is. I know I'm there from the 30th of August, 5th and 6th of September.
Yes.
So yeah, we're going to a lovely swanky hotel on the marina, which looks beautiful. So I'm really excited about that, and I'm delivering speaking at that as well. In fact, on neurodiversity and mediation, and how we can best support clients who are neurodiverse and may need different requirements. So yeah, it's going to be good. Looking forward to it. Looking forward to some sunshine.
Exactly. Well, we'll definitely put all these links on the show notes on the blog post for this video, so that if folks want to learn more about Charleston and Bridging the Gap, they'll be able to follow through on that. And one of these days, I hope you can come back and talk about neurodiversity. It's something that I don't know too much about, but I always love to have people come on and talk about it. Okay, and so before we close out, so thank you so much for all the talk you've given us today about MIAM, the Amicable Divorce Network. It's all part of the same thing, really, which is shifting momentum from the adversarial nature of litigation and the fees making approach, to line lawyers' pockets, to more of the people who really matter in this, right? The families, the children especially, in helping bring attention to different ways of doing things that are not just traditional and filled with acrimony.
Mm-hmm.
And by the way, being a lawyer, being a litigator, and going to court a whole lot, I will say for all the lawyers out there, don't get mad at me. There's a role for you, and and people need justice. Definitely, it's just that family law is specifically not criminal and it's specifically not civil litigation, right? Family law deals with children and people, and we can have all the Texas family codes we want, we can have all the laws we want, but ultimately, these judges and us lawyers, we can't make people moral. We can't make people right. And the only way we're going to get close to that, where people are going to build a bridge themselves and help their children just have a more positive experience that's not as toxic, is to help them, gain the skills of communication, gain the skills of being able to build trust again. All these things are done in a therapist's office, in a counselor's office, in a mediation office, not in a courtroom.
Mm-hmm.
Okay, period. So that's what you've seen, my 15 years anyway of doing this kind of work.
And Mac, I totally agree with you. There's absolutely a role. Of course, there is a role for solicitors and barristers, etc. But those roles are to deal with the legalities of separation, or to intervene where that there are, is public law matters and things like that, and to deal with the legal documents. But it is not that their job isn't to negotiate. That's not where they are. Their job is to act in the best interest of their client, and they wouldn't have any work if they didn't do that. But acting in the best interest of their client isn't looking to find solutions, and certainly solutions with any sort of longevity, which will support the parents to have a better co-parenting relationship moving forward. So there's absolutely a role. I'm not saying that there's not a role. There really is. But that role isn't to find a solution. That role is to fight for your client, to ensure that your client is getting a fair, that they know where that boundary is of what fits within the legal remit, as opposed to going, this is the best thing, we're going to fight for this for you. You're not here and the other party is over here. We need to move from these two positions to here, and then they make their decisions within that bit. So it fits within the legalities. That's really important that it does. I'm not sure what your guidelines are over there, and I imagine that they're state to state, but we have obviously the Matrimonial Causes Act, Section 25, which speaks about finances. And then we've got the Children's Act, Schedule 1, which also protects children with those things. But there's definitely a role, but this isn't a legal matter. It's a private matter, isn't it? Apart from the legalities of ending a marriage, which is a legal entity, and dealing with the finances. But certainly the children, they are not assets. They are children. They're human beings. And we shouldn't be utilising court time and space to manage what we should be doing for our children. We should be finding ways to work together, improve communication, and find solutions ourselves.
Yeah, well said. Okay, to close us out, let's talk about the Resolve Enrichment Program. Okay, I think this is a good way to end, because we're going to be thinking about the future now, about children who are the subject of all these cases we're talking about right now. These kids one day are going to be growing up to become the next generation of parents themselves. Mm-hmm. And are we going to pass on to that generation some of the conflicts that we are dealing with in our court systems right now amongst families? Well, we want to do better, right? And so one of the things that you are really good at is helping pour into the lives of children knowledge on how to deal with conflict, how to negotiate, how to resolve issues of dispute without resorting to your fist, without resorting to just, giving someone a tongue lashing. But how do you maintain control? And how do you make sure that you can promote good, amicable resolutions to conflicts? So can you talk to us about the work you've done in that area and the work you've done here in the U.S. as well? Not that you work in the U.S. What I'm saying is you've taken what you've done in the UK and you've brought it across the ocean. So please share with us.
Mm-hmm. Yeah, so I guess we first started on this project 3 years ago now, I should think. I was linked in with some people over on your side of the pond, a very deprived school where a wonderful man who's recently retired, Michael Cunningham, had established the ability to provide the training for and qualify children who potentially didn't have a great potential outlook because they were from an incredibly deprived area,
Yeah.
so that they were leaving school with the ability to be trained as mediators, the civil mediation certificate, and in fact then looking into the family mediation certificate. And then we were working kind of as a network of people who we picked up some of these students, we offered internships, things like that, so that we could, and I know there was a real need for Spanish speaking mediators as well. So a lot of skilled mediators, qualified mediators, US and probably more US side, who actually required Spanish speaking mediators were giving these children these opportunities, and also helping themselves to kind of fill a gap that they needed to fill with the Spanish side of it. A lot of the students were primary language was Spanish, secondary was English, so they were perfect for it. So that's how we got involved, and I did quite a bit of work with Michael, and there were a few others of us involved, and we had the most wonderful experience of coming over to Austin, Texas, and working in a school for 2 and a bit days. In fact, myself and my colleague went back for an additional day because 3 of the students didn't get their opportunity to, and we had like a little mini mediation competition. We joined other countries as well via the internet. They didn't get their opportunity to do their mock mediation. So we went back the next day to make sure they had the opportunity to do that. So we were really working with them to those soft skills and those skills that we can that are available for everybody in a world where communication is becoming less and less and less. Technology is taking over. It was really about inspiring the children, just getting on a level and being more humane. How do we resolve things? How are we going to communicate? How do we become active and good listeners? How do we work to find a resolution? And how do we negotiate? How can we put our point across in a less aggressive manner? How can we explain ourselves better or be heard differently? And if we're not heard differently, or if there's two people in dispute, how can we help to summarize what one person is trying to say, but it's not being heard by the other person in the way because it's hitting that kind of barrier where it's heard and it goes through this filter of negativity, and regardless of how neutral it was or how positive a statement it was, it's heard in a negative way. So being able to summarize and reframe things that have been said to help where there is conflict and disputes and things. So we've done that, and then we took that project also to a school over here in Nottingham. So we worked for a year with students, and we basically taught them all of those soft skills, but with a view to, maybe you do want a different career, and it appealed to a lot of the students. It was their enrichment program, so they got to choose what they studied as part of their enrichment program. So I think it attracted a lot of those that were looking into law, etc. But there's conflict everywhere. There's conflict, that from wars to neighbour disputes to, conflict. I'm a mum with 3 children. There's conflict sometimes in my house because there has to be rules, and different people have got different perspectives. But if you don't have a way to resolve that, you're always going to live in conflict. So it really is about just reminding people that we're humans, we can communicate. This is how we've evolved all these years. And we're becoming more and more and more into a dog-eat-dog world, aren't we? It's very money orientated, all of these things. And actually what we need to be guided by more is just being more kind, and reminding ourselves that we are human. Let's draw on those natural skills of empathy, supporting each other and working as we used to as a community. We used to always say it takes a village to bring up a child. Absolutely it does. We can't do this on our own. We need to have those bigger influences. So teaching children, I think also allowing them to understand what happens in the adult world when people do separate, but teaching it as this might be a career that you want to go into. So I'm hoping it's of interest. But actually, we're giving you the skills of knowing as a child what is the process that mum and dad might be going through right now, and how might it impact on me if that is what comes about. So it's really kind of educating them on those soft skills, those skills that they can take into any workplace, into any arena, and hopefully be better human beings, but also to ensure, marriage rates are going down and divorce rates are going up, and I don't think that's ever going to change. We live in a world where everything's renewable and you can upgrade, right? We're never going to end up having separated families. It's only going to increase, isn't it? And so I think what we need to do is, we know that generational trauma passes, and we also know that children of separated families are more likely to end up separated themselves. So it's about making that change, because when is it going to happen and who's going to do it if we don't do it? So I hope
Yeah.
that kind of answers the question.
Yeah, no, absolutely. You said a whole lot. I mean, like
Sorry.
buzzwords like empathy and reframing. These things are skills that we need to all know, but we're not born knowing them. Right? Well, we should be, but we're not born knowing them or exercising them because we have other things modeled for us that are negative. And so it's great that you come in, right, to the gap, right, and you bridge it and you try to address, the issue this way. So thank you so much for that work.
No.
And yeah, and it reminds me very similar to peer mediation. However, this is taking it so much further. Okay, because you're correct. One day these people are going to have to go to work and they have to deal with the coworkers the same kind of way. It's sometimes not what you say, but how you say it. These skills need to be taught to the young people and to their parents so that we're not repeating these cycles into the future. So, Katy Harris, thank you so much for coming on the LMIPodcast.com today. And I will remind people of your websites if people want to connect with you. You're on LinkedIn, of course. You're the founder of Mediation Matters Midland, and they can go to mediationmattersmidlands.co.uk, and Midlands has an S.
Yep.
And there they can learn more about you. Your page, of course, has your bio and all the other information that they might need to know. And of course, you're part of the Amicable Divorce Network. And hopefully I'll get the founder on one of these days to talk about this. And finally, folks who are interested in MIAM or any policymakers in the US, want to incorporate something like that into their court system, I think this is a great model that they can take a look at.
I would always be happy for anyone to reach out if they want just any information, if they want to kind of pick my brains on anything, ask any questions. My passion really is for this change, whether it's the UK, whether it's globally. Anyone that wants to jump on that ship with me, please come and join me. We need more people. We need to collaborate. So yeah, absolutely feel free, anyone, to reach out.
Yes, awesome. All right, everyone, thank you so much for checking this video out. Watch this and all the other ones on YouTube at LMIPodcast.com. Okay, take care.
Thank you.